Hi guys, my name's Logan, and I decided to research the topic of international criminal law and its effectiveness in an era of isolationism. My research revealed that isolationism promotes ideologies consistent with pessimistic, amoral, and inward-looking motivations. For these reasons, we can see an increasing lack of support and therefore effectiveness in our current binding legal order. To better understand the shortcomings of the International Criminal Court, I'm going to walk you guys through the process of what they aim to enforce and then address the difficulties that arise when interpreting and applying the law on a global scale. I often use the United States as an example, as they have challenged the application of international law in a number of ways. International criminal law aims to maintain peaceful relations globally by enlisting punitive measures as a means for deterrence for committing heinous crimes. Heinous crimes are those that are more or less universally agreed upon to have detrimental effects on human rights and ultimately humanity, such as war crimes. Once these offenses are identified, they are codified in the Rome Statute to be referred upon in the occurrence of a breach. The Rome Statute outlines a number of punitive measures to be enforced on individuals who are determined to be criminally responsible. Consequences include imprisonment, fines, and forfeiture of assets. These can be considered peaceful conflict resolutions as they achieve a degree of justice without resorting to retributive measures involving military. States who agree with the overall pursuit of peaceful relations are then motivated to cooperate with one another, entering into treaties which are further backed up by the punitive measures enforced by the ICC. Entrance into these treaties is based on consent to comply to the guidelines and accept consequences. Consent and cooperation is informed by a state's cost-benefit analysis of the scenario, where the cost is sovereignty and the benefit is protection. Certain cultural beliefs may cause one element to be weighed more heavily than the other, such as the United States' deep-rooted foundation on an independent and coherent constitutional design. This means that sovereignty will be granted additional importance. Additionally, political forces may play a part, while they heavily inform military budgets and presence. The United States' strong military force can be seen to reduce their vested interests in treaties such as NATO, as their need for protection is quite low, while their obligation to provide protection to other member states remains high. Here we can see how a state's willingness to comply may be influenced by other factors. After defining the laws and agreeing on who will be held accountable by them, there are still a number of issues within the system itself that make it difficult to uphold. The ICC exists independently from other international organizations while it enforces the articles put forth by the Rome Statute. That being said, there is a point of jurisdictional intersection between the ICC and the UN Security Council that allows for the Council to defer international legal proceedings when necessary, ultimately undermining the power of the ICC. One example of this can be seen when the Security Council acted under Article 16 of the Rome Statute to postpone investigations in the US in order to please political leaders in the country. The United States initially refused to allow the investigations to pursue and failed to cooperate with the ICC. The resolutions provided by the Security Council made it so that the lack of cooperation could essentially be considered legal. This highlights the issue of consent and cooperation, as they are the basis for international law yet have been shown to be unreliable. Further jurisdictional barriers arise when executing legal proceedings that require obtaining evidence, subpoenaing witnesses, and issuing arrests. Although international tribunals may request these resources, they do not have the jurisdictional authority to enforce the requests. Now that we've addressed structural flaws, we can see how they result in a number of substantive issues regarding the interpretation and application of the law as well. The meaning and power of the law loses substantive effect through first its structure and also its content. Definitions in the Rome Statute can be criticized for being vague and indeterminate, allowing for certain crimes to be overlooked due to loophole effects in the codification. The increasingly isolationist Uncle Sam uses military power and political influence to its advantage, while creating conflict between international organizations and undermining their power. The stability of alliances is strongly based in shared burdens and risks, and as countries like the United States continuously avert burdens, higher risks are placed on other states. All of this together results in weakened perceptions of the global order and ultimately weaker bonds to its promise. Have you ever heard the saying, a chain is only as strong as its weakest link? If strain is put on the chain, the weak link has the potential to cause everything it upholds to fall down. This works to prove that isolationism reduces the effectiveness of a world global order. Some interesting propositions I came across while researching suggested that willingness to cooperate is hindered by the looming punitive measures in place by the ICC, and that instead of having a punishment-oriented approach, a more rehabilitative method should be adapted. Other sources suggested that strengthening the bond of the international legal body and its members could only be done by evoking a more democratic method that allowed member states to more actively participate in the politics of the organization. What do you guys think? Do we need to adopt the current global order, or do you have faith in it as is? Here are my sources in case you found this interesting enough to further investigate. Let me know if you have any thoughts or questions.